I'm going to turn off my video so that I'll disappear and that all the focus is on you and the presentation. Okay.
Nice seeing you. Take care.
Yep.
Julie, nice seeing you again.
You too.
Thanks, Julie.
Hopefully the dog doesn't start barking. She's been real rascally since the snow started because she can't get out.
Not going to bother me. It shouldn't bother you. It's fine. Or
Okay, well, let's get started. I'll just make some quick announcements. Good morning, everybody, or good afternoon. My name is Rachel Husna, and I am with UNM's Division for Community Behavioral Health. Welcome to our Law and Mental Health Didactic Series. Just a couple of quick announcements about our CEU. In the last 5 minutes of the lecture in the chat, we will submit an evaluation link. Click on it, copy and paste it into a browser, complete the evaluation, and upon completion, a certificate is automatically generated for you. It's your responsibility to save it. So if you're on your smartphone, you'll want to take a screenshot of the document. And if you're on a laptop or a computer, you'll want to save it as a Word or a PDF, whatever works for you. If you're joining us by phone, you can just email me and I will email you the link to the evaluation. And I just wanted to remind folks, because it seems like the last couple of sessions, people have been hitting the evaluation all at the same time, and it's been overwhelming the website. We're a small outfit. We don't have like the greatest technology, so please save the link if you come into any difficulties with it. Everything's working fine. It's just the traffic is crashing the system. So just save the link and you'll have 48 hours to complete it. We will be sharing the recording of this lecture as well as the slides a bit later this week. I will email out the slides and the recording link to everybody who's registered for this lecture. And I think that's it. So I'll hand it over to Julie.
Thank you, Rachel. Welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. So first, I want to let you know, please join us next week. At that time, we've got Craig LaRue, who's going to be presenting effective expert testimony. Next for our talk today, we are going to have to get off right at the hour. So if we have time for questions at the, we will be taking them at the end. Please ask them at any point that you feel comfortable, but just know we may or may not get to them. For those of you that want the CEs but are on a tight schedule, remember you do have to stay for that full hour, but you don't have to stay on longer than that. And we should be ending right at that hour. But if not, I'll jump in and let you know when that time has come. So now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Michael Vitacco. Dr. Vitacco is a board-certified forensic psychologist whose research focuses on best practices in the broad area of psychology and the law. Specifically, his research is focused on the treatment and prevention of violence among individuals found not criminally responsible and returned to the community, evaluating how forensic psychologists can appropriately utilize social media information in their forensic practice, detecting atypical response styles in forensic evaluations, legal applications of psychopathy, and evaluating and treating violence potential with individuals housed in forensic inpatient hospitals. Dr. Vitacco has extensive experience working with justice-involved individuals, especially those adjudicated not competent to proceed to trial or not criminally responsible because of mental illness. He's also worked with individuals on probation or parole and individuals who've been civilly committed. As part of his work on conditional release, Dr. Vitacco has partnered with multiple states to evaluate conditional release effectiveness with individuals with serious and persistent mental illness. He's also researched psychopathy and its correlates, including stress reactivity, with juveniles placed in detention facilities. Dr. Vitacco has over 100 publications in the area of mental health law And in 2020, he co-edited a book titled Forensic Mental Health Evaluations in the Digital Age, a Practitioner's Guide to Using Internet-Based Data. Dr. Vitacco, we're so grateful for your time and expertise. And on behalf of the University of New Mexico, I'd like to welcome and thank you for presenting today. I'm now going to turn it over to you.
Very good. I appreciate that. Thank you much, Julie. And we'll get started. Just a couple of things. We're going to kind of skip the brief bio. Just recently have moved to the Institute of Public and Preventive Health and the Department of Psychiatry at Augusta University. Kind of a new position. Excited about that. And then I just want to let you know the disclosures that I do receive royalties from the book that Ashley Batastini and I co-edited. And a lot of this presentation today is really based on the information found in that book. So this will kind of give you just a really, really brief idea of some of the topics that are discussed. This presentation too is not very data heavy. It's a very pragmatic and practical approach to using social media data. I don't think it'll go the whole hour. And I think we will have some time for questions. So I think that'll be a positive thing. I am that guy today. I'm actually dressed in shorts and a running shirt. I mainly have to leave because at 3 o'clock I have to run across town to coach varsity track at my son's school. So on a tight schedule, but we'll make this work and hopefully it'll be pretty successful. Go with the disclaimer. These are all my views. If I say something terrible, do not hold anybody at the University of New Mexico responsible. It is entirely my fault. So here are some of the learning objectives today. Just want to talk about some of the pros and cons of using information obtained from social media in forensic evaluations. Because I think as we look at the data from social media, certainly can help us a lot in giving better opinions. But yet there's a lot of difficulties and some ethical issues in relying on that information. And we're going to talk about both the pros and the cons today. I'm going to talk a little bit about recent research, and then I want to link that research to guide how to use such data in forensic evaluation. Because again, internet data is only going to be increasing in usage in our discovery and what we can find. And then discuss again some of those ethical issues that are bound to come up, especially as we look at new sources of data. And we think there are some basic ways around that are ethically sound, but yet it's important to realize what you might be getting into if you make the decision to rely on data found on social media. So let's look at the pros of social media. And my guess is if we would take a survey, we're not going to do that today. A lot of folks on here today have already looked at Twitter, have already looked at Facebook, because this type of communication around us has really made our lives easier. As we still are in the middle of a pandemic, social communication through these resources have really improved our lives. It's easy and quick, and it really provides us instantaneous access to a whole lot of things across the country and across the world. And then here are some of the other things is that, as we know, probably more so now than we ever have with the recent issues at the Capitol and across the country, is that social media can also be the source of a whole lot of disinformation. So while it provides us great communication, it really also provides a tremendous amount of disinformation that can lead to problematic behaviors. In addition, the use of social media has made some criminal behavior much easier, much more accessible. If you kind of consider predatory behavior, reaching out to people, kind of getting a hold of potential victims, social media has allowed that. And there's a whole slew of things, even on sexually based offenses related to social media, because these things have become very, very prominent. And as you look at that, it is really one of those negative areas of social media. And then there's a whole lot of information that has happened within the last 10 years where individuals have used social media to broadcast crimes. And that in and of itself has a tremendous amount of forensic implications that go along with it. So just want to talk a little bit about 4 possibilities related to this forensic implications of broadcasting crimes, especially when we want to, as forensic evaluators, look at some of the motivation or rationale behind some of these behaviors. And here are 4 of them that Dr. Batastini and I came up with. The first is just trying to become famous. I mean, we see this all the time, is that people will broadcast themselves doing things that are otherwise illegal in an attempt to kind of make a name for themselves. Nowadays, people will use the broadcasting crimes to make some sort of statement, often political. Sometimes the motivation of broadcasting crime is simple, and as simple as they just want to have evidence that indeed they did what they said they did. And that could, again, be for a whole lot of reasons, but even the mere fact of documenting a crime can be part of that reason they broadcast it. And then, as we often see in teenagers and adolescents, it just may be a side effect of having impulsivity or poor judgment, that as they're doing something that they think is fun, or they want to make noted, that they're just using poor judgment. And all 4 of these things, as you kind of go through these, if you get this kind of information, each of them has a different forensic implication, and really warrants kind of consideration in each of those things. This came from just a regular news site out of England, but there was an article just on the broadcasting of crime, and specifically related to younger folks. And they talked about, they weren't doing it for confession. They were really doing it because of the immediate kind of rush they got and the hilarity from that. And often what they said here is that when they kind of got into some of these data, that these young people were doing this mainly just for the sake of sharing it, and implied that they didn't understand necessarily the severity of the crime, but maybe how this would shock other folks and motivate other folks. And I have little doubt that some of the school shootings, which have been linked to social media, if you would have went back, even in the Columbine instances, social media would have played a much more prominent role in those things, because certainly they were trying to make statements and do different things like that. And here again, this is another example. As this man was found murdered on Facebook Live, and critics then were wondering, what is the Facebook's ability to moderate violent content? And of course, as we see now with various individuals getting censored and changed, and these are things that we are going to, as forensic practitioners, going to have to deal with more, and we are going to see likely more and more content related to social media issues. So a lot of this presentation today is going to talk about what to do with that, how to get to that, and to do it in an ethical way. There's a really famous case that many of you may be aware of, but it's the Alonis case in 2015. And what Alonis did was very interesting, but he was under this pseudonym called Tone Dougie. And what he had is these various raps on Facebook. But as he was becoming separated and divorced from his wife, these lyrics that he was posting took a very ominous turn, where there was perceived violence and threats towards many individuals, including his ex-wife, coworkers, and even members of a kindergarten class, I think, that his children were a part of. What he did that was interesting and different was that when he was kind of writing these lyrics, there were various disclaimers on these, that these lyrics were just fictitious. He didn't really mean it. But as you'll see in a second, the lyrics themselves were quite graphic. And certainly if they were written about me, I would be concerned. And this is exactly something that came right from his page, is that I'm not going to rest until your body is a mess, soaked in blood and dying from all the little cuts. One of his lyrics kind of alluded to the fact that the police were arresting him. How did they know he wasn't strapped with a bomb and he wasn't going to blow them all up? Various things like that. Ultimately, he was found guilty in district court of threats, and that conviction was confirmed by an appeals court in the United States. But what ultimately happened, the United States Supreme Court ruled that in an 8-1 decision that the conviction could not stand because it wasn't enough just to say what a reasonable person test was. The argument being that a reasonable person reading this lyrics, if they were directed at them, would indeed feel threatened. The argument is that the intent mattered, and the mere fact that he put in the lyrics that this was part of his art and that he was willing to go to jail for his art was enough to mitigate the fact that that wasn't actually a threat. Again, I'm not posting this or talking about this for any sort of way to say what's right or what's wrong, only a matter of this is where the law is and what the Supreme Court said in 2015. But it certainly makes for an interesting sort of ideas if you're conducting risk assessments or threat assessments and are kind of given these data as part of your evaluation. And it does make you wonder what you would do with it and how to integrate it appropriately into your threat assessment. So these are things that I'm certainly aware of, both anecdotally and through research, is that we know that social media content is becoming increasingly part of discovery. I get all sorts of information very regularly in discovery provided me by the legal system related to different posts on social media, private messages that have been obtained on social media. And often when you get these things, it contains a lot of useful information. It provides very good information related to those 4 things I spoke about earlier, but about motive and where someone's, what they were thinking, what they were feeling, what they were talking about. But the thing that you must be aware of, and we all must be aware of, is that certainly as we start going through someone's postings, there's also the big chance that it may contain biasing and irrelevant information. And we know through just a slew of research that has been occurring that certainly these types of data have the potential to bias us. So we must be very, very careful when making the decision to look at these information because of the likelihood that it may provide a high level of bias. And sometimes we may not even be aware of it. So here's just a very different thing, is that Caslow et al. In 2011 really talked about very, very strongly against basically a psychologist not turning into an investigator. And because there's really no reason to start diving into the personal life of your client. And I would agree with that 100% from a therapeutic standpoint. As a clinical psychologist, if you're seeing someone for treatment, I personally believe that you should probably not engage in a search of their personal ideations and different things like that because it doesn't matter. However, when it comes to a forensic role, Halbrand et al. Talked about the role of the forensic psychologist as similar to that of an investigative journalist who uses all information available to them to reach conclusions. Glancy et al. In 2015 really talked about how internet data can be used to validate or refute information. And as we go further into this, that's exactly what I'm going to be speaking about. The question is, how far should you go? I always talk about this, is that if you've seen the Netflix series You, if you leave with nothing today but this, I think we'll all be better off. In You, the main protagonist uses social media and various things that he comes across to stalk people, to get inside their head, and then he ultimately ends up murdering several of them. So, if I leave you with anything today, follow this: is don't stalk people, don't murder people. Those are bad things. But outside of that is that we do know that information provided in social media can be very, very useful. So here are some 5 recommendations, and some of this comes from Gina Perella and some of his work, but talk about we should use internet data, and when we use them, we should contextualize them as a form of collateral data. So it's just another data source. Forensic practitioners, you should weigh internet searches and forensic evaluations on a case-by-case basis. Here's the bottom line on that, and hopefully this isn't a surprise to anyone, but if you don't need it, there's no reason to go look for it. If it's included in the discovery and you think it is going to be helpful for you, then absolutely, it is something that you should do. But do it sparingly and do it carefully. With rare exceptions, forensic practitioners should discuss the reliance on social networking sites during retention and informed consent. I often will not do this. If I'm going to go look for something, the reason is that unlike a lot of other records, is that social networking sites data can be scrubbed pretty quickly. So if I feel it's something that I need to do, I will do it after the fact. But again, you weigh that on an individual case. Listen, if there's also something I need to do, importantly, and I get that information, I will often allow the defendant to take a look at what I found and allow them to address it. That's really important to get context, to get different information, because they may be able to provide some additional information that I would not have access to. And also, too, I've had at least on one occasion where the defendant actually changed their story pretty significantly after realizing that kind of what they were saying was very much against all the other information in the data in their case. And like anything else, we should always be very explicit about what we do, the information that we gathered, because certainly you want to be forthright about that, and it allows the opportunity for cross-examination on your methods and to allow that information to be vetted as well by the defense, the prosecution, or anybody else. Okay. Determinative consent is needed. That's true with anything else. Verify the authorship of the post. One of the big things that very much often comes about in social networking data is that you can't always be 100% sure who posted the information. You can be pretty sure. I mean, you can talk about that, but you may have to understand that information. You may not be always aware of what has happened or who has posted that information. As much as possible, look at the reliability and clarity of the data. How does it fit with this individual? Is it consistent? Is it not? How clear is it? And be very, very careful to not read into the data that you get from social networking, because indeed, they may mean a very different thing than you're thinking it means. If you don't understand something, one of the things we advise doing is getting someone who might be more, kind of up to date with the lingo to help you interpret maybe something you don't understand. Here's the thing: is determine whether it represents fantasy or fiction or represents a defendant's true thoughts. Look, this can be very difficult, as we saw in the Alonis case. They decided that the Supreme Court did that it wasn't a threat because it was part of his art. It was part of his free speech. I recently had a case within the last several years where someone was brought into our hospital on a civil commitment hold because they were afraid that they were going to blow up a school based on some posts that they made. And kind of disentangling that was very, very critical to making a appropriate recommendation to the court. Corroborate as much as possible. Listen, this is, again, no different than you would with any other collateral source. Question the meaning and context if you're unsure. And then always look at how the data may have impacted or biased your assessment. You're going to hear this from me, you've heard it from me a couple times already, and probably a couple more times, but there's no doubt that we're prone to these types of cognitive errors. And then determine the data's relevance, which, again, if you don't need it, there's no need to go look for it. I was, a few years ago during an election cycle, I was actually taken aback by something a colleague posted on social media, a colleague who did therapy, but the therapy client they had supported a certain political candidate. And this individual basically said very explicitly on their social media that this person didn't deserve therapy for their depression because of who they supported. Those types of issues and those types of concerns certainly become very, very relevant when you start looking at data that might have nothing to do with the task at hand. Okay. So we looked at some how people look at these things. This is an article published in 2018 by Adam Coffey and Ashley and myself. We looked at 102 forensic mental health professionals. And what we found is that the use of social media data are really most common in mental status evaluations, insanity, and child custody and parental fitness. So people and evaluators in those fields using those type of evaluations really rely on that. And we'll talk a lot about the pragmatics about this in about 15 minutes here. But what was really interesting is, as a sample as a whole, social media was not ranked very, very helpful. It was just what they viewed as slightly more helpful than inmates as a collateral source. So even the folks that were using it still did not see that as very useful. Certainly, then, something to be aware of as we move forward. But almost 64% reported consulting social networking data. And again, in child custody parental fitness, 95% of evaluators check profile information at least once. This would be one of those things where you would certainly want to talk about and let both parents know what you were going to do. From a criminal context, about 83% of individuals conducting mental status evaluations looked at these data at least one time. So these are pretty robust results when you kind of look at overall. And again, my thinking on this is as this becomes more embedded in our society, we'll see this used even more. So this is also interesting. The sites that were used most frequently are Facebook, YouTube, and Twitter. It's amazing what you can find on YouTube these days from some of our defendants posting things. 53% was found in discovery. So it's actually given to you, actually vetted by the prosecution or the defense. But 42% of individuals looked at things and did their own search. For the most part, my advice is that if it comes in discovery, you probably are a lot safer. On at least one occasion, I have gone on and did my own search. And that was an interesting case where we got a report from another expert that talked about this individual's inability to use social networking and different things as part of a rationale for their decision in a competency case. We did a basic Google search and we found all sorts of videos posted by seemingly this individual. We couldn't verify authorship 100%, but it was clearly the individual on the video. He had some very distinctive marks, and it was very helpful in kind of at least rebutting part of the other expert's opinion. So these are the things that are highly useful, and again, to do it or not to do it should be really evaluated on a case-by-case basis. So these are what the data really show here, is that most felt it could be useful, but again, the most concerns really kind of worried about the validity of it and the ethical concerns of using it. They were worried that, of course, if they use that information in a legal aspect, it might be thrown out of court. Notably, those individuals by a strong margin who had no concerns or who have never used social media, social networking as part of their criminal cases or civil cases, had the most concerns about it, just about its validity. No differences on legal concerns, which was also pretty robust. So these are the four primary concerns when looking at social networking data from social networking sites. First is authenticity. Talked a little bit about that. Second is just the reliability of it. Is it really consistent? The third is privacy, which we're going to get into a little bit. And of course, the one that I've highlighted as well is both the relevancy and the irrelevancy of using this type of information, because you are going to get a lot of stuff that just doesn't matter. Here we go. But this is really how we think it can be helpful. The first is looking at someone's thoughts, feelings, or behaviors in closer proximity to the target behavior. So certainly in a criminal responsibility evaluation, going back in time and looking at someone's posts around the time of the alleged offense can be very, very helpful. As part of the discovery of a criminal responsibility case that I had, I actually got instant messages from someone basically acknowledging that they messed up and had to get out of town. And in the state that wrongfulness is part of it, that data, those data were certainly very, very helpful, again, into assisting with reaching an opinion. Certainly is not dispositive, but really kind of put out into that direction. And then, the other way is just corroborating or clarifying something someone said in a clinical interview. For example, if their thoughts are all over the place or have a hard time focusing, and you look at various posts that show just the opposite, their writing is very, very cogent, things that at least would kind of give you some hints and some things you may want to discuss later in your clinical process, in your clinical evaluation. Look, I've certainly seen this in a couple of times in friends that I had on social media, where it looks like that their social media posts are becoming much more disorganized. They're posting much more, and clearly appear to be related to some sort of even a bipolar episode they were having. So that information, again, can really look into various patterns. And then we get an understanding of kind of what's going on with their lives, right? How are they relating to others? How are they responding to others online? And that certainly can, again, give us some insight into where this individual is at a certain time, place, and related to a situation. And all this information can be developed together to inform lines of questioning. And again, we certainly would not suggest anything found on these counts are dispositive of anything, but certainly is very, very useful. It might be helpful in looking at different lines of questioning. So we're going to talk about various forensic cases with social media implications. And these are the 8 discussed in the book: criminal responsibility, competency to proceed to trial, violence risk, violence threat assessment, sexual offending risk, child custody, pre-employment, personal injury, or fitness for duty. However, for the sake of this talk today, I'm really only going to be focusing on 3. The 2 that have been most primarily used are criminal responsibility and child custody. But I think one that is very much up and coming is personal injury. And we're going to talk a little bit about legal ramifications and various things with that, just to get a sense of kind of how they're used and different things that sort of works. So we know this. Criminal responsibility are retrospective evaluations, days, weeks, months, years. About 8 years ago, I actually had a case that was 20 years old, where obviously there was no social media. But what we sort of indicate is that you can use social networking information, and it really, in these cases, can provide a lot of relevant information. The first is just overall patterns of functioning. How is this individual doing over the course of time? And specifically, if they're posting, if they're tweeting different things, very much during the time or around the time of the alleged events. Often we will see historical information that is very consistent with the presence of information, the presence of mental illness, information directly related to what seems to be someone who is having issues with reality and various things like that. And then there are those rare occasions, and I mentioned it just a little bit ago, that information that strongly and directly kind of points to having some ability related to right from wrong. Again, the example that I used talked about the individual who kind of wrote to a buddy on the night of the alleged offense that something bad happened, that they needed to get out of town, that they were aware that they were in trouble and they needed to go into hiding. So, again, although not 100% related, that really gives you some line of questioning and line of insight into their behavior at that time. But really important in those types of things. And these are the type of evaluations that, if available, I think is very, very useful. But here's the thing with this. It's data that's generated in real time. Is data that someone is tweeting about, that is time-stamped. They have a Facebook account that they post something. That's data that's generated in real time. So it really provides you with a great kind of insight into where those individuals are at that time. But consider these types of cases, and again, I think we're going to see more and more of this, especially what happened sadly at the Capitol, is you're going to see individuals where they're writing lengthy anti-government statements on social media, or they're tweeting various things or retweeting different things, and then they go out and they they commit an alleged act of violence or an alleged act of vandalism and different things. And to kind of link these data is very, very helpful. But these are some things that are always very, very helpful to hypothesis development is what is the context of what this individual is saying? What is the context of what this individual is tweeting out? What is its relevance then to their specific behavior? What types of things then are they engaging in that are problematic, or are there other contexts of behaviors where they're posting different things and then there's no relevance whatsoever? Are there any sort of indications of psychotic thought? And again, that's where if you sort of take these in its whole, in its totality, where you can sort of link context of the situation to psychotic thought. Is it a momentary thing where they're just kind of posting something out, or is this a long-term sort of process where they're showing where they're kind of losing their train of thought? They're becoming much more disorganized, much more rambling. These things, again, can very much be part of the information you gain from social media. And then there's information, obviously, if they're claiming to be a sovereign citizen. One of the things I've always heard about that is, how do you know if you're dealing with a sovereign citizen? Well, usually they'll probably tell you within 30 seconds. Not my area of expertise, so I don't know if it's true. But often these types of anti-government statements will be very, very prevalent on any sort of social media account that they have. And you can clearly see then where, kind of what their beliefs are. There's actually a video embedded in here. I'm not going to play it, but as you get these slides, I would encourage you to take a look at this because it really deals with a lot of the issues of privacy versus helpfulness. And the experts on this video, it's about a 3-minute clip, but they get into just a lot of that information where they talk about the very big balancing act that must be taken into account. I do want to just kind of point out now, before we even get it further, generally courts have not recognized in these types of cases and these type of trials any sort of social media exception to privacy, meaning basically that if something is posted out there for the world to see, it is fair game to be used. Now, the one caveat, there are certain states that certainly have rules against that. For example, using it as part of pre-employment evaluations. However, for the most part, if you put something out on social media and it is accessible to the public, it's accessible to a large number of people, you cannot then claim that that was a private post and that someone shouldn't have access to it. So something to kind of keep in mind as we move forward. The courts have generally not recognized that as any sort of private or privileged information that is inaccessible. So here are some issues with social media and child custody. First of all, child custody evaluations, if you do them, fantastic. It's just very, very complex. And social media is important just for a lot of reasons. We're going to have some actual examples here in a second. I will warn you, some of these are PG-13. One of them is PG-13. But social media data, again, is used very, very regularly by evaluators who do these type of evaluations. I think we found out of those evaluators, 95% of people look at social media context at least once. So people kind of going through these things, if you're doing that, your social media will probably be looked at. And yet also one of those things that can provide data that are directly relevant to child custody. And yet through all that, you must keep in mind, we must keep in mind the real possibility of impression management and various things like that people do on social media, and this would be very, very relevant for child custody. We also know that there's been numerous studies that talk about how people who are online a lot looking at social media accounts are more prone to depression because they view everyone's life as fantastic and always traveling, and of course no one posts their day-to-day dribble, and I'm probably guilty of that as well. But these are some things that might be very, very helpful from a social media perspective. The first one is posts directly targeting other parents. And believe it or not, this happens fairly regularly, where you will see a parent targeting another parent, their former spouse, looking at various things like undermining their confidence or their emotional stability. Activity on blogs or support groups, and this is interesting. This kind of has come up as well, is that when you look at these things, for example, a parent who is following a blog or posting things about parenting or co-parenting with a narcissist. Clearly, the implication there is that their ex-spouse is a narcissist or is a problem. But the bottom line that you're seeing there is that this type of information certainly can potentially be alienation as well. And then, which gets into the third point, is that you may see some of this as that evidence of alienation of children, inappropriate home environment. Often people, it's amazing what people will post, and I'm going to get to a couple of prime examples in a second here. If you see a lot of evidence of drug and alcohol use, actively disparaging the judge or process. And again, you may see someone, again, they may just be ranting. They may be, if we kind of get back into motivation, they may be having an impulsive moment, but it certainly doesn't look good if this person undergoing a process is then going home and posting things on Facebook about how awful this all is. Evidence of a new partner, luxury spending in the middle of things when they're saying that they don't have income to kind of, provide child support or different things. And then looking at just their use and their children's use of social networking sites for their communication and their communication styles and various things. These can all be extremely relevant when it comes to child custody, and provides a lot of information, which again is no surprise then when you consider that the vast majority of individuals who conduct these evaluations do look at social networking sites as part of their process and part of their evaluation. So this actually was a response from something we from our 2018 survey. Is this person posted a video explaining how upset they were, how unhappy they were at having their child removed, and they were posting this while on clearly using methamphetamine for the camera, indicating that as they had a pretend child or a stuffed animal, that there was no deficits in their parenting ability whatsoever. So again, this is just one of those examples where more so than anything, it's probably very much on point at what a court would want to know regarding child custody and parenting ability. Here's another prime example of something that actually happened during a custody dispute. This mother, I guess, swore and yelled at her 10-year-old son, called him an asshole on Facebook, and then indicated in her Facebook postings that it was important that her Facebook friends understood that her 10-year-old, what a problem he was, and I guess that he was an asshole. And the court actually took this very, very seriously, and basically sort of said that her lack of insight into the process was problematic, as was her lack of remorse into the inappropriateness of such behavior. And they issued an order of protection in the custody dispute. So again, these were things where I guess the parents weren't necessarily worried about kind of their reputation on Facebook as much as they were just about kind of getting their opinion out there. But in both cases, I think we can see where this would both be highly relevant to the issue at hand, and the courts, would use this information to assist in making a appropriate judgment. And talk a little bit about disability and personal injury. And this is the last thing we'll talk about today, then we should have plenty of time for questions. But one thing we see more and more in disability is that there's this claim damage, and then it's related to head injuries, anxieties, depressions, attention, impulse control, PTSD. And people who do these talk a lot about how frequently and how the whole process is growing, that a Facebook video or Twitter video or something that is posted on social networking sites becomes admitted into the court process, often obviously as a rebuttal to the claimed injury. And this really speaks to someone, evaluating someone's functional capacity and deficits. There's been talk where people said that, they could barely walk. Their back is in so much pain, and then they are posting videos, or someone is posting videos of them skiing down a hill, and various things, which obviously would clearly be in complete opposite to the disability that they're claiming. And this is really where you get to focus on response files, as stakes can be very high for the claimant and the respondent in these cases, and very, very expensive. So, if someone is claiming a direct injury result and they're posting various things on social networking, this is going to speak directly to the issue of disability or person injury at that time, and what they're going through. So, very, very critical to be aware of this. And this is an area I think that is growing, where you're going to see more information coming in from social networking sites. And again, this comes from Lisa Drago-Petrosky, who does a lot of these, but she really talks about how you can evaluate premorbid functioning, and that the use of timestamps are so critical. And you look at clues about consistency of functioning across various time, across various contexts, and across various situations. And what she noted is that there has been noted of a few limitations on the scope of discovery in these evaluations. So once someone is claiming this type of injury, and once the other side has posts that are, show a very different sort of scenario, these things are routinely showing up in court. Given that, as an evaluator, and I don't do a lot of this work, I certainly would want to be aware of the existence of anything that is available if I'm going to make that sort of claim. And this is, comes from our chapter 9. It just says really what you want to do is you want to approach internet data in much the same way as any other collateral source, with an awareness of its merits and flaws. And really, that's really what I hope you've kind of taken away from this, just brief talking about social media, is that just an awareness that there are a lot of merits to using these type of data, but it comes with just a tremendous amount of inherent flaws. So, taking that balanced approach and using it when only appropriate is really the way to go. And this is just one of those, I think, that really highlights some of the issues with social media. Here's the post on my left of what the guy is doing. He's at the beach having a great day, and then someone takes a picture of him from far away, and he's just in his backyard, really kind of pretending. And this really highlights some of those concerns. These are some recent references, including a in-press paper we have that talks about perceived credibility of social media data in criminal responsibility evaluations. And I'd be happy to send pre-copies once we get the final prints, if that's something that's necessary. But we have about 15 minutes. I did want to end a little bit early based on my schedule. So I think, Julie, you're going to read out the questions and go from there.
Yep.
Fantastic.
Thank you so much. Yeah,
All right,
we do have a number of questions.
Excellent.
So can you please speak more to the determination of whether consent is needed?
Yeah, absolutely. The bottom line is when I do these, and I've done this again numerous times in my evaluations, there is nothing, again, based on any sort of law or anything that would require consent. So if there is something that I think I need, something that might be useful in an account, social media, I'm going to try to look for it. Often what I'll do is go then and talk with the defendant about that information. In many cases where consent really becomes strongly needed is if you're going to do anything pre-employment. Some states have very strict standards. I think California is one of them against use of that information. So you really have to be aware of your local standards. But in a basic examination, forensic examination, I don't believe you need to get someone's consent to go look for what is essentially public information.
So if you did your own search and you found something that you believe to be relevant, would you recommend notifying the attorney that retained you and have them vet it first before including it in your report?
Yeah, that's a great question. So I think that needs to be considered. But I think here's my, this came up in a talk that Ashley and I did at APLS regarding this, is that the problem you risk with that is then you are now kind of giving away your best practices, what you think is appropriate, to the attorney. And I don't recommend that. I certainly am not opposed, and I certainly have made attorneys aware of what I have found. But if attorney says, I don't want you to use that, it would really be no different if you're doing your evaluation, they tell you something, do you just exclude it from your record? I think that is where we get into an ethical issue, is that you are then at that point completely losing your objectivity. And you have given that away. If they don't want to retain you at that point and that it's work product, and that may be a separate issue. I have also the advantage that for the most part, I'm not retained privately. So certainly as a state examiner, I would be under no other sort of compulsion to give that information away or not use it. But I would, I personally, I think when you give away your standard of practice to an attorney, you risk being surprised. You risk your reputation being undercut in front of you as you're testifying. For example, doctor, was there anything you're aware of that would have changed your opinion or be contradictory to your opinion? If you say no and you're aware of that, you've obviously just committed perjury. And I think that would be an issue.
Have you seen instances in which people are becoming wise as to the fact that their social media posts are being used and maybe purposefully create or delete posts that would shift or minimize criminal responsibility?
Yeah, not in criminal responsibility evaluations, but I think, and I don't do this work, but I bet if there's a child custody individual out there, I bet they have seen all sorts of things that I probably am not even aware of, including the creation of new accounts with various pictures. That's why timestamps are very important. It would be very obviously weird if you get access to someone's social media account through a custody evaluation and everything's been uploaded in the last week or 2 weeks or month. And then lo and behold, it's a public account. But I think those are the instances where that would become much more likely, people who are sort of aware. There's actually a slew of websites where lawyers talk about the use of social media and concerns about what you might have on your social media through, that can be discovered. So I think that's where you're more likely to see it. But I think as we talk more about this, as more papers are published, as this information gets used more, we'll probably see that happening as well in criminal cases.
Thank you. So there's a lot of questions about how we obtain access to this stuff. So questions about, are you only looking at stuff that is public?
Yeah, great
and
question.
bringing up the fact that, people's sites are generally private, or is there a way to request this type of information from social media sites? Yeah, that's
a great question. Well, so let me be very, very clear on that. Is a tremendous question in questions if people have asked that. I am not going to friend a defendant to get information. That's a really, really bad idea. I am, and I think I think there's all sorts of ethical quagmire you're walking into if you do that. The information that I have gained has been either given to me via discovery, where the prosecution or the defense has gained this information. On the other hand, if it's public, and often it is, I certainly will use it. But and there's been some practices in some states that have prohibited people from friending people just to get information, especially in pre-employment information. But I'll only look at it if it's public. And it includes, I've used YouTube videos, there's been Twitter posts and Facebook posts, a couple other ones that have become prominent these days. But no, if it's not there, I'm not going to otherwise look for it. And when it just comes to this stuff, and again, if we had more time, there's all sorts of ways these data have been used, even by jury and trial consultants who have used information found on people's social media accounts to kind of select juries and kind of get people that they want to serve in their juries. And that stuff has been ruled that's all okay to use. But I would be very careful how I get it, but only public searches is what I what I really recommend.
We have a comment here. This individual says, this is interesting. In some cases in which I've been involved prior to social media, the court has not allowed any evidence that the other side did not know about, like a recorded fight with an automatic voice activated machine was not entered. Florida rules in custody cases.
Sure. That makes sense. So often, again, when I do find that information, and again, I think we have a tremendous responsibility to make everybody aware of the information that we found and how we've used it. I don't think I need to, again, ask someone to get permission to review public information, and I've never have done that. But once it's out there, and once I have looked at it for what I need to do, I'm very much aware that I do think it needs to go with obviously my sources of information, and I can be cross-examined on those data, if I have used them.
This next individual wants to know if there's a best reference for social media information for child custody cases.
Well, I'm going to say we have a book chapter in our thing that can actually be purchased individually. So folks that have actually done those have wrote a book chapter on it. So that's what I would recommend. It really goes through a lot of the issues, and both ethically and how it can be used in that. And I understand that that's a conflict of interest. I'm saying that, but really it really is the one source just published in 2020 that has all the information kind of present in one source.
What do you make of the idea that individuals don't have a full understanding that anything posted to social media is like having a private conversation with no expectation of privacy? Yeah, well, I mean, that's the same in any sort of other collateral information almost you will receive. And the video on the James Home page, actually, some legal experts kind of discuss that. But certainly, I understand that, but I also think that's fair game. I mean, we do a lot of things that we think might be private that are not, including who we say things to and different things like that. So I think that's okay. This individual works with a law enforcement agency with issues related to pre-employment evaluations, and the agency asked the prospective employee to allow the background investigator to have access to his or her social media. Is this something that forensic psychologists can also implement?
I wouldn't do it because, again, I don't know exactly. Well, I'd like to know more about that if they can respond real quickly. I have about 5 minutes here. I'd be careful. If that involves friending or anything like that, the answer to me is a solid no. That would be a no on that. If it involves just access to it, my concern would be is that you might be asking someone to allow a private thing to get public for the sense of incrimination, because it could have a legal inference. So I wouldn't do it. I would absolutely respect that. And courts have generally ruled, that there's a slew of cases on this, that anything that's designed to be private, if there's a lot of protections on it, may not be as admissible as someone that is clearly not under privacy. So for pre-employment, each state does it a little bit differently. And of course, if their state is doing that's based on their laws. But at this point, there has not been a lot of stuff legislated done on the criminal side, and it might be coming. I don't know. But I would be careful. I'd be careful, especially to do it criminally. I see that as being much more ethically gray than just searching for stuff that is otherwise generally public.
All right, maybe final questions so that you can make sure you get to your meeting.
Gotta do some running.
All right. Are there recommendations about what procedures and methods that you would use as a standard search?
Yeah, well, what was interesting is that often you can put basic searches into a Facebook page, and if it's someone's name, it comes up. On the stuff I've used on YouTube, it was as easy as putting that individual's name into a Google search. I mentioned that another expert said that they were so impaired that they couldn't even use any sort of social networking site. Basically, a simple Google search found that was very relevant. That information came up, and there was that individual, again, with very distinguishing marks. Clearly them. Authorship was not an issue. And, really provided some additional information on not just their functioning, but on their I don't want to give much away on that. I just want to say that it was very fruitful to see that information. I think I have time for one more.
All right, let's see here. What do you think about providers posting okay, hold on. Let me see if I can. What do you think about providers posting information on social media?
So there's actually been some guidance on providers doing that. And I think that the guidance is very useful. In a longer presentation I recently did, I talked a little bit about this. If you have a social networking site specifically linked and only linked to your business or everything else, feel free to post relevant information on there. But if it's your personal one, I strongly would be against that, to post like data on your business on your personal Facebook account. And the other thing too is I think just for your own mental health and well-being, keeping those as separate as possible would seem to make a whole lot of sense to me. So if you have like a business Facebook page, post business stuff on there. If you have a personal Facebook page or other sort of networking, keep it personally, and that way it's very, very separate. Plus, in this day and age, there's no promise that your stuff won't get subpoenaed. So you may say that, hey, my personal stuff is off limits. Well, your professional account certainly would be. I don't want pictures of my kids showing up in court. And I understand it's a possibility. That's the nature of things, but I would try to avoid that as much as possible. And that comes, there's been a whole slew of guidance on that. And I think it makes complete sense.
Well, thank you so much. This was
Thank
fantastic.
You,
really appreciate it.
Thanks, Julie. I appreciate just how you guys have been just wonderful. Thank you very much.
Thank you so much. Have a great day.
Take care, everyone.
Bye-bye.
Bye-bye.
For those of you that are still on, we've got the CEU link up. So we'll give you a few more minutes to complete that. Otherwise, we will see you next week.
Thanks, Julie. Thanks, Efrain. Take care.
About how much more longer, Rachel?
I'm gonna log us off because I put it up like 15 minutes ago, so I think we're good.
Okay, sounds good.
Thanks, A. Have a good day. I'll see you later.
See you later.
Okay, bye.